Miller representing SKRE LLC. I'd like to reserve 7 minutes for rebuttal, if I may.
How many?
7.
The rule here is 5 to 5. What the max 5?
Yes, sir.
Yeah.
As a brief summary, SKRE petitions court to revert somewhat Byzantine and ambiguous discovery order entered in the lower court, which fails to take substantive and procedural protections regarding non-parties, regarding potential trade secrets and other confidential information there, and therein departs from the essential requirements.
What is this order miss? I'm sorry.
Seems to me that what your primary concern is documentation that has to be retrieved by the parties. Subject to the court order, that the main
Specifically with the language of the court order, paragraph 1A, B, and C, direct SKRE to go to third parties and retrieve information. And
and under 1A, you see that retrieving.
And that we've already provided, that's not a dispute. What is in dispute is that the language in 1A requires, it directs SKRE to provide to the respondent in writing the names and ownership information for the defendant, SKRE, that's not part of the objection, and the names and ownership information for any entity which the defendant or any of its owners, including Mr. Coletta and Mr. Eckert, are affiliated.
What's wrong with that?
Because it's requiring us to then ask third parties, being Mr. Coletta and Mr. Eckert, and any other entity, who you affiliate with, and then get that information from those affiliates.
Define the word affiliation.
There was an objection made to that the word affiliation and a number of other words in the discovery request were ambiguous.
Your main argument say for affiliation only. You want that clarified, limited?
There was some.
It is a little bit ambiguous. Affiliation. I mean, they play cards with them, they play golf with them, they own them. I don't know what that means either.
You're hitting exactly on the ambiguity.
So what is it you
And
want?
it's fans.
What is it you do?
What we're petitioning for is to basically strike from the requirements any reference to any other third party or what is listed here as any entity which the defendant or its owners, John Coletta, Roman Network, are affiliated. Therefore, we do. They did in their capacity as representatives of area. That's correct. Paraphrasing the contract language, but there's more to that contract language that is a dispute between the parties, and it's not just 5% coming from their
So I
letter.
don't understand what the problem is. Law that are affiliated. Is the problem why not create the privilege law that was also in Europe?
Because the privilege law wouldn't be Gary's privilege. It would be a third party's privilege. The information could be privileged in fact.
If you just put parties down on the law, then the judge can do an inspection and decide whether there's been merit rejection.
We've already indicated that we don't have the power to determine what is a third party's trade secret objection. I don't know what any entities, these third party entities, deem. It's not our privilege. We can only do a privilege law on our privilege. I can't do a privilege law for a third party entity. So
maybe I'm going to think of this way too simply, but it says to give the names and ownership information, okay, including whether they're affiliated.
yes,
Okay. SKRE as officers, managers, these are managers. I think is what they're called.
Yes.
Right? They're two managers.
there are two minutes.
Okay. sitting in their official capacity, the court has asked the company to disclose this information and provide it. Does the company have a duty to go to the officers and say, do you know this information in your official capacity? And if they don't, they don't, which, you know, that would be another question. But that, it doesn't sound like that has even been done, because you're raising this as if they're third parties, when a company actually has individuals who run it. And the way that I'm looking at the order, that's who they're supposed to, you know, provide that information. But, and I don't, that's obviously not your argument, but I have another question, because I don't know that we have jurisdiction, and I don't see the irreparable harm here. When you've not responded to, or we don't see where there's a privilege log or it's gone the next step. So I find that the petition is a bit premature, because I don't think there's been that next level, given the court the opportunity to determine some of these other issues that you're raising. If you're talking about trade secret, but I don't know what privilege we're even dealing with.
So Your Honor, I believe there's two questions, two comments there. The first one being, isn't it just easy enough that the court is saying, and the respondent has requested information from SPRE itself? Information.
Defendant is, SKRE is the only defendant, and the court says provide the names and ownership information for any entity with which defendant, or any of its owners, including are affiliated. If the defendant, who are the officers, have that information in their official capacity, then they should provide it, it would seem to me.
That's the nature of our response as part of the record. We actually did respond to that. We have provided SKRE's information. We have provided Mr. information in his capacity with SKRE. We provided Mr. Roman's information in his capacity with SKRE. The court then said that's not enough. The court has then said, Miller is
Do you have an order?
SKRE.
You have an order saying that? You have an order saying that?
Yes. It's the order. It's in paragraph
I want to
1A.
make sure.
Paragraph 1A directs us. Where
Where does
You
it
talking about the
say?
same order on appeal?
Yeah, I'm.
You're right.
It sounded like you're talking about the same order we're talking.
This is the multiple ambiguities within paragraph 1A, because it does direct us to provide.
When you say us, you mean defendant, because it only says defendant is to provide.
And the defendant is SKRE.
Correct.
Right, and defendant is directed to provide information that it has, and it goes through a series of dependent clauses to its own information, which we have provided. Information, and here's where it gets far afield, where it says that defendant must provide ownership information for any entity for which defendant affiliates.
If it has, and I guess that's where I'm confused, because on record page 231, Mr. Miller, that's you, says if SKRE is in possession of those, we've agreed to provide those.
Yes.
So if you're not in possession of, you can't provide what you don't know.
Exactly, that's.
So, but I don't see where this order is, we're reading it in a very broad sense and stretching it to provide for third parties, because you're probably anticipating what's going to come next, but I don't think that's what the order says.
Well, I mean, that's the basis of the litigation, and that's the context of in the responses, or I'm sorry, the request is to actually have entities for which SKRE affiliates their language. They under their version of reading of the contract are responsible to pay the plaintiff additional monies.
Right,
So
but this order doesn't seem to be reaching out to non-parties like some of the other cases where they direct a third party to provide information. I mean, this seems to me it's only directed to the defendant.
well, I read 1A saying it is directed at the defendant, clearly, but it is also directed at information that is in possession of Sean Coletta's affiliates.
No, about, I mean, it's. A defendant can only provide what they're in possession, custody, and control of, right?
Absolutely.
Okay, so I'm not seeing where this goes beyond.
It is, I read 1A to indicate that the court is directing the SKRE to not only provide what's in its possession. It goes on to indicate that if there's an entity for which SKRE affiliates.
Yeah, but if they know, they may not know. I don't know. That's a different issue, like I said. If the company has business records that they're aware of who the other entities are, the owners, for whatever reason during their practice, then they have that information. So,
Your Honor, that's precisely our response in the record. And the court then sanctioned us for
It
not.
seems like we're one step premature
Yeah.
because there's no response saying. We have a lot of records, and look, we got all, here we have nothing. Why? Because here's the privilege log that we think we cover some of this. Is the judicial labor finished here, I guess, what I'm getting at.
I think it is when it's regarding SKRE, but, and then after the response was provided to the other side.
maybe that's what we're missing. Can you point to something in the record where there was some sort of response or compliance or notice in the record that you complied with the motion to compel and that there's some other order outstanding that we're not aware of?
Well, it's a motion to compel that's on appeal, so.
No. Did, when this order was entered,
Yes.
was there any records responsive to this order submitted and provided?
After the petition was filed.
No, because
The order.
after the order came out, prior to
and
the
then
petition.
was filed shortly thereafter.
Okay, so this would be the point, is where's the opportunity for the court to correct? I mean, that's not our job to correct what I think you're asking us to correct. 'Cause on a petition for cert, we can only quash the order. We can't enter direction.
I think perhaps, I should explain it this way. Your honors are hitting on exactly what are the proper vehicles for discovery. They asked of a request, we have a response, there's discussion, they filed a motion to compel, and it went to hearing, the judge issued an order. And that's the order for which I've requested relief on petition for writ of cert.
But you took an appeal before trying to comply with the order.
On the language of the order that I think is out of bounds. So to the extent.
Under whether you feel order is reasonable or what you do. But you do a lot more into that order than that.
Well, let me at least have the opportunity to explain what I'm reading into. What I'm reading into it, and I think the language is plainly there, is that it is ordering SKRE to produce what it has, which is under the rules. But it goes beyond that to say that SKRE is directed to grab ownership information of
No,
people
it
other than
doesn't.
SKRE.
It says provide the names and ownership information for any entity with which defendant or any of its owners, including Mr. Coletta, Mr. Eckert, are affiliated. Like I said, if the company SKRE has that information, then they're to provide it.
Then I want to back up because our response describes that we, just by virtue of our response, which indicates it's responding to the various questions, the various interrogatories.
Well, I'm gonna assume you want 5 minutes.
Yes.
Okay, then you're down to 5.5, and you're not repeating yourself. So
Sure.
between now and 5 minutes, which is 35 seconds, you can keep going, or you can save that time, whatever you want to do.
Well, I'm doing my
I
best to
think we're
answer.
going in circles. I'm just trying to mediate. Let's move forward to say something different, or sit down and come back and do your 5-minute rebuttal.
The point that I want to make on opening then is the particulars that I believe are written into 1.A involve secrets that are trade secrets for not only for in the possession of
You didn't, there's something you didn't say. Something a broken record. You said that, I think we get it. I'm just trying to save you time. Now you're at 5 minutes, so keep going or,
I'll save my time for the vote.
okay. Right, now let's move on to someone that has a chance. That's Megan Serrano.
Megan Serrano, yes, I was my. Thank you. Good morning, Your Honors. May it please the court, Megan Serrano on behalf of Tennyson County to respond. The standard of review of the discovery order is whether the order is perfect in the essential requirements of law, causing material injury to the law. It's responded contention of the course.
Well, let me just ask you this. He's saying the order is overly broad. I'm filing an appeal because I don't want to end up with a discovery law and something, whatever his position is overly broad. Do you agree or disagree that the language is overly broad, or is he reading something into it that's not there?
I believe he is reading something into it that is not there. I think the order is extremely narrow. It is much more narrow than what the plaintiff, Mr. McMahon, was requesting that the court do on the order.
So it sounds like you would stipulate to the words being revised and amended discovery order being issued if necessary, but I get the impression that you were seeking sanctions against him for not complying timely.
We did, and I think I can clear up some confusion here. So the order was the order of events. The order of events was that this order was entered. This petition was filed, and subsequent to, not quite sure the timing of the motion for sanctions and the petition, but the motion for sanctions was filed, but it's never been heard. So anything addressing the motion for sanctions is at this point premature. Subsequent to this petition.
But the filing alone sets forth your position and belies what you just said, that you wouldn't be seeking sanctions for trying to have the claim the order requires him to reduce something he doesn't have, or it's overly broad.
Except that then the petitioner filed supplemental interrogatory answers and answers to the request for admission, which are not per the record. That is the question. And I would note that in those responses, there wasn't a record. So again, referring to the standard, whether there was a departure from the essential requirements of law, is my position that it was not appropriately provided for protections for any privileged information that could be disclosed in the privilege law. To date, and this discovery was filed more than a year ago, no such privilege.
And what is your position on whether or not we have jurisdiction on irreparable injury?
The court does, of course, have jurisdiction to correct that. The idea being that the case did not proceed as filed, this is going to be.
No, but is there irreparable injury here where the court asked, where the court directed that the defendant provide this information and provide privilege law if there was any objection to it? Are we dealing with something that's premature here?
No, Your Honor, and there is no risk of irreparable injury. There was no chance that trade secrets or other privileged information could be improperly disclosed. Privilege law could be provided for us. The order does not exceed the scope of authorized. Your Honor pointed out, LLC only has to its member managers. We know from the preliminary interrogatories that Mr. Coletta and Mr. Eckert are members / managers of the company. So if they have this information, they can just behalf of the company. This is not exceeding.
But okay, so but if they have the information in their official capacity, correct? And if basically it's the company has the information.
Correct, because the company, in this case, an LLC, can only act through its number of managers. And I would like to point out that both rules which I did do in this order are only to extend the explanation already include the requirement that the responding parties must make reasonable inquiry of himself, his attorney, his agents, his employees, to provide information. wanted to address was respondent has the burden to develop the discovery is and is on the part of the hospital. Because there was some objection that the request would be burdensome. This objection was raised in that instruction. So there are many reasons why, and of course, and for trial, the party may want to request the same information from sources. And it also ensures that the working things like documents, and by asking for that information, there's of course a certification for the party responding to the discovery that the information produced is accurate. The starting point, of course, for any discovery dispute is relevance. All the information that the court required to be disclosed in the order is relevant to the agreement. It's asserted, of course, as Barry wants tonight. So for all of these reasons, again, not believe the order of question the essential requirements of law, not causing material. Thank you.
I'd like to briefly address just two issues on both of them. The first is the issue of sanction. There was a motion for sanction described that's not always addressed in the brief. It's the sanction that the judge imposed by this order has to do with the fees and the costs associated with bringing it. That's what is the sanction that's referenced in the brief. So there is a later motion for sanction, but that's that leaves a separate issue. And that sanction is must be based in part because there's been some non-compliance with the original discovery order. We have provided responses in the original discovery order, and by virtue of the fact that the judge is telling you to do more, is why I read paragraph 1A the way I read it. We have responded with SKRE's information. We have responded with the ownership information regarding Mr. Fleto.
But that's still after the petition filed? Is it-
No.
Okay,
before the motion is
I'm
clear.
sorry. The interrogatory answers and some of the requested answers, those are things, some of those things were filed after that are not part of the petition.
Well, to specifically answer your question, yes, that's not what I'm speaking about now.
Okay,
Our responses that we believe were responsive to the requests from SKRE and from the two managing members and their capacity for SKRE were provided. They then filed a motion to compel, saying precisely that's not enough. We need your affiliates information. We need more than that. And the judge agreed and then sanctioned us in the manner of fees. When we did exactly what all three of your honors described as the normal course of discovery, we did that by virtue of the language that's in the order in front of us that says the plaintiff SKRE needs to do more. I'm sorry, the defendant SKRE needs to do more. And that's the basis for the petition. That's why we are here, and I think that conveys jurisdiction, because if the judge is in fact asking us to get information, documents, information from third parties, we don't have the ability to object on really any basis on their behalf, because they are independent third party affiliates. And Judge Valencia is correct. What's an affiliate? I don't know. But the judge has already told me it's sanctioned me once. So I have to come to you and say, judges, what should I do?
Let me just answer this one. If we can help you get something in writing, we feel our hands are tied by the standard review, and you'll understand why. Okay? That's not what we're gonna do, but we're gonna chat about it. I feel your frustration, I feel your pain. They're doing their job, you're doing a great job, you're both doing a really wonderful job. And this is what happened in discovery among two A-heads. I mean, you both have different interpretations. Get that, take the gloves off and say, this is what we're talking about. We'll go away.
I appreciate it. That's all we're asking for is review on what we think is outside of what is, it follows the normal chronology of normal discovery. And then the judge says we need more. So that's where we.
You're both overthinking. That's just my humble opinion from the cat side. And you're both great people. I love this, but I don't want to see you suffer self-imposed. And that's what you both do to each other. So we'll figure it out. We'll help you if we can. If we can't, I make no promises.
Appreciate that. That's all I ask.
All right. So listen, have a nice day. Thank you for coming here.
Very much.
We'll be in recess.
All rise.
Thank you, John.
Thank you. Travel safely.